Hello everyone, welcome back to another session of Facebook Live, wherein we will be taking up all your queries which were left out in the previous session. We hope the last session was pretty helpful for a lot of many of you, and we were able to resolve your queries to a great extent. Moving on.
Hello friends, I am once again Advocate Nidhi Singh, founder NRI Legal Services, and the young lady with me is my senior legal associate Nikita Kohli, advocate, and this is in the continuation of the last session where we got an excellent response. There were a lot of topics that we touched on last time, and due to paucity of time we had to leave certain topics, but we are getting a lot of inquiries. We are flooded by a lot of inquiries. Nikita is going to bring up some, and accordingly we would be explaining, answering and making you understand the legal concepts behind those queries to the best of our ability. So Nikita, let's jump into it because time is always a constraint.
Right.
Yeah.
First question I would be just taking up. My sister has inherited a small portion of property along with me. She is a US citizen now. Earlier she was in India. How can she save tax on sale of such property since I have the power of attorney to sell?
Right. Very quickly, whatever tax is accrued in India, she'll have to pay that. And there is a double taxation treaty and with the US and India, and whatever residual taxes that she has to consult her tax attorney in the US, without paying taxes and without getting, if it's an agriculture land, then there is an exemption on tax. But in any case, she has to get a tax clearance certificate. Only then she can repatriate those funds. So paying the tax in India, she has to do it. Whatever is she has to consult a professional, and then she can repatriate those funds. However, Nikita, we get a lot of inquiries on women's rights, and I would like to explain this concept of what is really happening, what is the journey towards from women not inheriting to inheriting completely lands and properties that belong to their father and their ancestors. And this journey, there is a lot of there's a lot of noise, there's a lot of sound. Oh, women have been given equal rights, and now there is no difference between a man and a woman in their inheritance rights. So if I can briefly trace this journey, I think to the viewers it will be very clear exactly what are the nuances of this. So so there was for the longest time, women were not inheriting any lands or properties in their parental properties, and mostly under section 6, the devolution of coparcenary property, that is the property within the family, used to only devolve on the male successors. Now, this is absolutely a gender discrimination, and also it is complete negation of the right to equality, which is a fundamental right. And this section 6 has been under scrutiny for the longest times, where various women advocate groups and even the Parliament Committee for Law and Justice stood up and said that this is a complete negation of the fundamental right guaranteed by the Constitution. So finally, after several years, finally in 2004 the bill was introduced in 2004, and in 2005 this section 6 was completely amended, giving equal rights to 2005 complete equal rights to men and women in their parental lineage. So this was a huge revolution, and in the right direction. This is how a democratic, progressive society should be, and the law upheld women's rights and gave equal status, tried to diminish the oppression that women would generally face by not even being a party to any kind of inheritance. And this was a turning point. This was an iconic moment. This was huge. Section 6 was completely amended. Now started the interpretations of it. the interpretations of various things. So there was this cases that went into the court. First they said, oh, so that means properties, so there is a judgment, and then there is a change in the law, and then there is an interpretation. So in the interpretation what happened was that they said 2005 के बाद की जो properties transfer होंगी वो उसमें औरतों को और बहनों को और बेटियों को right मिलेगा, उससे पहले नहीं, which means that it's only after 2000. Then the cases were filed and Supreme Court very clearly said no, this is retrospective. It doesn't mean that it's only from 2005. A daughter can claim the right from her birth. It was very clear and very nice statements came. A daughter is a daughter all her life. You cannot just say that it is only after 2005 she will gain that right. So that was finished by one judgment. Then the second judgment came, oh, in case the father has died before 2005, she cannot get a right in the property. Then again there was a Supreme Court judgment negating that completely. They said it doesn't matter when the father has died, a daughter stands to inherit the right in her father's property irrespective of whether the death of the father happened before 2005 or not. So that was also quashed. Third, again then there was a confusion that if all those who are born before 2005, girls who were born before 2005 will not inherit this property. Again Supreme Court clarified on this issue that the age doesn't matter. It's not that it's only after the girls born after 2005, but right from the start. So a woman will inherit rights in her parents' property. So unequivocally Supreme Court on every issue has been upholding the rights of the women and have been saying that this is retrospective, this is a permanent amendment, there is no change in this, women's rights are being recognized, which is very, very good. So this journey from 2005 and then 2020, there was and now in between what happened here was very interesting, that people try to loop the law, or they try to use the law to their advantage, and that is what happened. And a lot of people said that in the co-parcenary property, in agriculture lands, in property which is completely the fifth term of males, a married woman wouldn't get rights. So there is a brand new judgment which is Vinita Sharma versus Rakesh Sharma, and it is dated 11th August 2020, which even quelled that and said women are equal participants even in the co-parcenary property, and even married daughters and unmarried daughters, all of them are equal rights holders to their father's inheritance. The only thing here that I would want to tell is that only those properties don't come under the purview where the partition has happened before 2005. मतलब कि अगर प्रॉपर्टी डिवॉल्व हो गई 2005 से पहले और पार्टीशन भी हो गई, तो हम कह सकते हैं कि वो प्रॉपर्टी को मत तंग करो. बट अदरवाइज अ वुमन नाउ हैज full rights. She can even call for a partition after 2005 if the partition has not happened in the joint undivided Hindu property. She can call for a partition and she can get her share, demand her share out of that property. So one by one 2005 से लेके आज 2022 तक सुप्रीम कोर्ट ने एक एक करके जितनी भी इंटरप्रिटेशंस उसके सामने आई, उसमें सिर्फ एक ही चीज़ देखी जा रही है कि औरतों का राइट, वुमेन का राइट पूरी तरह से सुप्रीम कोर्ट ने प्रॉपर्टीज़ एंड लैंड्स में दे दिया है. ये 2005 के पहले भी है और उसके बाद भी है. फादर की डेथ कब हुई, 2005 से हुई, किसी भी चीज़ का कोई फ़र्क नहीं पड़ता. Women, sons and daughters are completely equal in terms of their inheritance rights today. But we are also being flooded by questions which are still a grey area. And I will want to tell you where this Hindu Succession Act falls a little short. And इस जर्नी में जो 2005 से 22 तक है, अभी भी एक माइलस्टोन है जो कवर करना रहता है और जिसके बारे में हमें क्वेश्चंस बहुत आते रहते हैं. एंड आई वुड लाइक टू टेक दैट अप, दैट व्हाट हैपेंस इज दैट This is a central government act. This is a center act and a central law, and this is prevailing all over India. Land acts are also under the state list, and there are state tenurial laws in Uttar Pradesh, Himachal Pradesh,
A few states.
and a few states like Uttar Pradesh, Himachal Pradesh, Punjab, जहाँ पे अपने रूल्स हैं इन एग्रीकल्चर लैंड्स के बारे में. वहाँ पे क्या हो रहा है कि क्योंकि बार बार कोर्ट्स अगेन एंड अगेन हर एक चीज़ को क्वैश कर रही है और वुमेन्स राइट को अपहोल्ड कर रही है, तो बहुत सारे ऑब्सोलीट लॉज जो हैं वो ख़त्म भी होते जा रहे हैं. यूपी हैज़, उत्तर प्रदेश हैज़ रिवाइज्ड अ लॉट ऑफ ऑब्सोलीट लॉज. उन्होंने ख़त्म कर दिए इन फेवर ऑफ जेंडर इक्वालिटी. लेकिन और बिकॉज इतनी स्ट्रांगली वुमेन राइट्स के बारे में सोचा जा रहा है हिंदुस्तान में, भारत में, कि स्टेट को भी फोर्स करना पड़ रहा है कि वो डॉटर्स को इवन इन द एग्रीकल्चर लैंड्स हक दें. होता क्या है कि एग्रीकल्चर लैंड पे ही एक फैमिली डिपेंड करती है. तो क्या होता है कि वो मैरिड डॉटर्स को वो राइट नहीं देना चाहते, क्योंकि आउटसाइडर्स उस एग्रीकल्चर लैंड जिस पे वो अपनी रोजी रोटी कमा रहे हैं, उस पे वो मैरिड डॉटर्स की इंटरफेरेंस नहीं चाहते. तो उसको स्टेट लॉज ने अलाउ नहीं किया कि मैरिड डॉटर्स शुड ऑल्सो गेट दोज राइट्स. बट Nikita, this is what I really appreciate, is that I feel that even these state laws have now given equal rights to daughters. It is where it stops short abhi bhi is married daughters. So a lot of people say that I have done a lot of videos. So there was a question that came that said that, oh, I cannot inherit my agricultural land in UP. What women's rights are you talking about? So to those who are still suffering because of this, I want to say that the journey from 2005 to 2020 is progressively going towards establishing women's right completely, fairly and squarely. And now even in the state tenurial laws, which are very, very strict and gave no right to women, have also accepted daughters. To married daughters, married daughters can inherit, but they are still a little weak because they have given it in the third list, not in the first list. But I am very certain, looking at the attitude of the Honorable Supreme Court of India, that this is bound to happen. And anywhere where there is gender inequality or there is a discrimination towards women is going to be wiped out. A lot of controversy between this, why, who should prevail, but a lot of courts have upheld कि ये center का मसला है. And Hindu Succession Act, where Section 6 is amended, Section 4(2), which was an impediment, is also amended now. And I have a feeling that even in the state laws like the UP Zamindari Act and various acts, local acts, जहाँ पे अभी मैरिड डॉटर्स को हम नहीं दे रहे हैं full equal rights, there is only this last milestone or last landmark left, where I feel once we achieve it, we will be all across the country in every kind of property. 90-95% we are there, only 5% is left, but women will inherit equal rights in their commercial properties, urban properties. They're already there, residential properties, and they will be in agricultural lands as well. So I have no doubts about it. And now if anybody has a question still who doesn't understand, can absolutely ask me questions on this.
That was very beautifully explained
Yeah.
by you. Well, we've got a few queries on the live, then we can take up the other queries. The very first question is by Miss Sharbila Patel. She says that my mother had a share in a joint property and I am her only daughter and only legal heir. Now since she is deceased, so can I have right to claim the partition suit against my uncle in ancestral property? So
Yes, of course.
That's
If there is a partition that has not happened and your mother was a legal heir, and now her legal heirs can absolutely become parties to that partition suit. There is absolutely no doubt about it. That's what I've said, that any partition that has happened before 2005, you cannot open. That only little bit of that's gone. But after 2005, you can order a partition, you can join a partition, you can be a party to any suit as your mother's legal heir. There is absolutely no doubt about it. Yes.
Same question, it's about the married daughter again. Ms. Heer Bajwa, she asks that can a married daughter make a claim over her father's property along with her brothers?
Absolutely, but now here is very important, and we've been getting a lot of questions on this, and I want to clarify on this. You see, a lot of married daughters are sending us inquiries like this. This is not clear asking me directly, but a lot of married daughters are asking this question, and we say yes, of course, because as I've just explained, under the Hindu Succession Act amendment in 2005, now there is no difference between men and women, sons and daughters. But there is a situation which is completely overlooked, which is that married daughters are claiming rights in their properties even when their fathers are alive. Please note, whether it's a son or a daughter, you cannot claim any right in the property if your father is still alive. Inheritance means after your father passes away, then on succession, the sons and daughters stand to gain equal rights. Not before that. Even if you're married, your father is alive, you cannot claim anything. But once he's deceased, you can claim equally, just like your brothers can. Yes.
Thank you. Moving on to the next question. My uncle passed away and he has only 2 daughters. There is no division of property that has happened between my father and uncles. Whenever the division will happen, then both his daughters will get the same properties as my father will get, or as the nephew, I can have a claim on that.
You can only inherit your own father's property. Your uncle has daughters, that doesn't matter. I've just explained this whole concept to you. Now there's no difference between a daughter and a son or a married daughter. Mostly it is only your inheritance would only be towards your father's property, and the daughters of your uncle will take the share of the uncle. It's absolutely clear, cast in stone. So we need to understand this law and appreciate what a milestone it is in the completely rural, agricultural, backward culture that we come from, and how this law is being upheld, and how gender rights to women are being talked about in the most modern way, and how the society is now emerging from the shackles of sons' rights and negating completely daughters' rights, not empowering women the way women should be empowered. And I think I have a lot of respect for the Honorable Supreme Court and our lawmakers to take our society progressively towards making sure that the women are as empowered as men are. And I'm sure that whatever little variance is there anywhere in the country, that will also be settled, because the entire thought process towards women has changed, and women stand to gain so much, and they stand to get status, they stand to get empowered, they stand to not be oppressed, and maybe stand on their own feet and look forward to life just like any man would. So it's a huge change, and it should be applauded, and daughters' right upheld by every court of law right up till the apex court, and judgments and interpretations coming very quickly and negating everything wherever there is a discrimination towards women. So there is a lot of hope, and I think progressively we are looking forward to an amazing gender equality environment, and that is how it should be for all sons and daughters. Yeah.
Moving on to the next question, it is that the person is asking on the behalf of his wife. As my father-in-law passed away and the properties belong to my wife's grandfather, can she claim that? If yes, how much will she get? She has total 4 uncles, so the properties will be distributed equally in 4 parts. she has no brother, and it's only her mother, her wife and the mother.
See, I have explained this entire concept, but these are very technical questions. We would, we would like to answer them after we look at the tree, the family tree. We would like to look at what is the property involved. So this is specific. So specific questions, we would need more information to give you an accurate response. While the broader idea of what the Hindu Succession Act, rights of a woman mean now, and how various judgments have impacted it has been explained. And any specific question about still any doubts, kindly just send it to us. We will not be able to take very detailed questions. I would invite more dialogue for that, so that I can give you a response accurately.
The next one is can a woman sell her purchased or self-acquired property without the permission of her husband or the son?
Absolutely. See, this very question just shows how women think they're not even aware that once you are an owner, it doesn't matter you're a man or a woman, you have complete rights to sell a property. No one can deprive you of that, and you don't need anyone's permission to sell the property. This is the sign of oppression over the years that women are facing, that even while being owners, they are not sure whether they have their full legal rights to sell the property. So you're a bona fide seller, a bona fide owner of the property. You do not have to take anybody's permission. You do not have to ask anyone before selling that property, and you can do it very well.
I would like to just add on one point here. Rightly you've just mentioned that a lot of people, a lot of women are not even aware of, plus a lot of times even when they're aware of the same the scenario, but they are being forced to relinquish their shares also a lot of times, because knowing that probably they might not be having their share. A lot of time it happens. And there are clients of ours, a lot of times they don't even disclose about the having their sisters, and there are women in the family who may also inherit the property. Sometimes they do not disclose it, and other times of course we have a situation like the women are not even aware of, so they just relinquish and they just sign the paperwork for relinquishing their share in the property in favor of their brothers or like the other legal heirs. So they do that.
It's a conditioning in India that needs to change, that sons are the rightful owners, and it is changing. And the laws are supporting it, that it is the right in a parent's, the first right is the son, is a culture change. People also want to marry their daughters and not give the properties to their daughters. The law is now empowering women to do it. A very interesting comment from Nikita, I would like to say that there is now a rule that if a widow or an old woman is actually doing a transfer viva, that is a transfer while she's alive, in her lifetime, she's actually supposed to go to the deputy commissioner or the designated officer of that state, and she's supposed to sit there and tell him that she's not being coerced into it. There is no zabardasti. उसको किसी ने भी ये बोला नहीं है कि वो करे, वो अपनी पूरी रजामंदी से, with her own consent and free will, she is actually transferring that property. So to this extent now, the administration, the executive and the judiciary are going to make sure that women, as you said, they are made to relinquish their rights. So all the checks and balances are slowly coming in place, where women are asked not to come under any kind of pressure or oppression, and the government is trying to help them. So I feel it is a very, very positive thing. Secondly, we get a lot of cases where they try and hide the identity of a legal heir, being a woman. Yes. And I want to tell you कि ऐसे कभी मत करना, because this could actually lead to criminal liability. If you're trying to deprive a woman of a right and by denying her identity, it can actually get you into a lot of trouble, because the courts are not looking at it kindly at all. If you have a will in which your sons, you've given the property to the sons, then make sure that will is watertight, because even if there is a little bit of suspicion on that will, that will be set aside if the daughter's rights are being extinguished via that will. So make sure that this does not happen. In case there's a genuine this thing, and try and get the woman's consent, your daughter's consent. So if you're actually trying to give the property to your son, what will really help is that get your daughter to happily sign over, so that there is no confusion, because the courts do not look at kindly if you're trying to deprive your daughter out of it. So all of these are points that are very, very important, and people should keep this in mind. And also, talking of will, I think we should tell you that a will is not as relevant a document in India as it is in the West. What is the difference here is that in the West, a lot of everything is will. So you can will your entire property, and that's going to be honored. It's not like that. In fact, in India, more and more people, the courts are naturally more inclined to law of natural succession. So either a will is completely watertight, sealed with the right attested witnesses who can come and testify in court. It's got all the checks and balances. Otherwise, if will is challenged, it can be set aside in favor of a natural succession. So विल बनाते समय बहुत ध्यान रखें कि हिंदुस्तान में, भारत में विल की अहमियत उतनी नहीं है जितनी बाहर के देशों में है. और अगर एक विल बनी है जिसमें आपने कुछ लीगल एयर्स जैसे कि लड़की को राइट नहीं दिया है, तो आपको ये जानना और मानना ज़रूरी है कि वो विल बिल्कुल सही होनी चाहिए. वरना अगर कोर्ट को ज़रा सा भी शक हुआ कि आप लड़की का राइट को बाहर कर रहे हैं और लड़के को राइट दे रहे हैं, तो आपको उसकी शायद विल मानी ना जाए और विल सेट असाइड हो जाए. सो ये एक मैं आपको आभात करा रही हूँ कि हिंदुस्तान में, भारत में लड़की की इनहेरिटेंस राइट्स को बहुत ज़्यादा अब इम्पोर्टेंस दी जा रही है और माना जा रहा है. और कोर्ट्स बार बार जजमेंट से आ रही हैं जिससे कोई भी शक और कोई भी लूप होल या कोई भी वीकनेस ना रहे. लोगों को ये बात की समझ आ जाए और आती जा रही है. इवन टू द एक्सटेंट, जैसे मैंने बताया, कि रूरल कम्युनिटी तक, जहाँ पे बिल्कुल ही नहीं कभी भी लड़की का कोई राइट माना गया, वहाँ तक भी अब भारत में लड़की के राइट्स को अहमियत दी जा रही है. सो ये एक जस्ट एज आई सेड, बहुत प्रोग्रेसिव सोसाइटी की निशानी है. और किसी को भी किसी तरह की विमेन को किसी भी तरह की कोई परेशानी इसमें नहीं होनी चाहिए. और हाँ, बहुत सारे लोग, लड़कियां ये समझती हैं कि हम हक मांगे कि ना मांगे. आई वुड लाइक टू टेल दोज वुमेन कि आप अपना हक अगर अपनी पेरेंटल प्रॉपर्टी पे छोड़ना चाहती हैं तो लेके छोड़ें. एटलीस्ट टेक इट एंड देन गिव इट टू देम एज ए गिफ्ट. अगर आप लेंगे ही नहीं अपना राइट, तो उनको पता ही नहीं चलेगा, आपके भाइयों को या आपके बेटों को. अगर आप अपनी बेटी का राइट अपने बेटों को दे रहे हैं, तो उनको कभी नहीं पता चलेगा कि उनको ये गिफ्ट मिला है और वो उनका बुनियादी हक अब नहीं है. और ये बहुत ज़रूरी है अपने बेटों को और अपने भाइयों को ये बात का एहसास कराना कि ये हक मेरा है. मैं एक औरत हूँ, मुझे कानून ये हक देता है कि ये प्रॉपर्टी मुझे जानी चाहिए. और अगर मैं किसी वजह से नहीं ले रही हूँ और तुम्हें दे रही हूँ, तो तुम्हें मेरा वो एहसान मानना चाहिए. बहुत जगह तो मैंने देखा है कि विमेन जस्ट दे देती हैं और मेन उसको एक्नॉलेज भी नहीं करते. सेकेंडली, मैं ये भी कहना चाहूँगी साथ साथ कि अगर आप अपना हक ले रही हैं, तो हो सकता है, और बहुत सारे केसेस में ऐसा होता है कि भाई बात करना छोड़ देते हैं, या बेटे माँ से नाराज़ हो जाते हैं बेटी को हक देने से, या फादर से नाराज़ हो जाते हैं. सो आई वुड से कि इसके बारे में ज़्यादा मत सोचिए, बिकॉज़ अगर भाई बहन का रिश्ता या बेटे बाप का, बेटे माँ का रिश्ता प्रॉपर्टी से ही है, तो उस रिश्ते का कोई फ़ायदा ही नहीं है. सो उससे कोई परेशान मत हुए. इनफैक्ट आई फील मेन को तो और एक्नॉलेज करना चाहिए और graciously
be just giving the right.
Exactly, graciously they should give you the right. So do not feel bad if you're demanding a right in your parents' property, if you're demanding a right in your father. You're entitled to it, because in the eyes of law, men and women absolutely stand equal. There is no difference. Today's this thing, we have concentrated more on Hindu Succession Act, but एक छोटा सा topic, do we have the time? 5-6 minutes. We'll quickly do the Lis Pendens जो आपको वो question
There
आया.
was one, yeah,
So I
question
hope
particularly.
daughters' rights का जो topic है आज हमने squarely cover कर लिया है. Feel free to send your questions. There is one more topic.
Last question will be taking it up on the. This is the person who is from Australia. He says that I have a case going on my property in Punjab. One unknown person is claiming adverse possession on my property. Now I have got a buyer who wants to buy my property. So can I sell it?
So Lis
it's
Pendens
it's in the way that the
अच्छा,
property can be sold during the
pendency of the litigation. Okay, so we do get these inquiries where people say that supposing there is a dispute in a property and two parties are involved in that dispute, and the dispute is on who is the real owner, or declaratory suits जैसे कि होते हैं to declare the ownership of the property, और उस पे आपका झगड़ा कोर्ट में चल रहा है. So that means that it's called that it is Lis Pendens in the sense that that there is a case going on and it is pending in the court of law. So उसके लिए एक judgment आई है which is absolutely the latest, जिसमें बिल्कुल क्लियर कर दिया है. 2022 की जजमेंट है GT गिरीश वर्सेस वाई सुबा राजू. अब इसमें क्या किया है कि बहुत सारे लोग ये कहते हैं कि हमारी प्रॉपर्टी पे कोई स्टे नहीं है, क्या हम बेच सकते, हम तो ट्रांसफ़र कर सकते हैं. और यू नो हाउ स्मार्टली आपकी लड़ाई चल रही है, किसी ने आपकी प्रॉपर्टी पे क्लेम किया हुआ है, आप क्योंकि प्रॉपर्टी के पोजेशन में हैं या आपके नाम वो प्रॉपर्टी है, आप उसको बेच के सोचते हैं हम रफा दफा कर दें, वी शुड जस्ट गेट आउट ऑफ इट and the property is sold because there is no injunction on it, because there is no stay on it. So to them I will tell you that you can do it, and उसमें ना इस judgment के through court ने ये जो section 52 है of in the transfer of property, give your property, you're selling the property, but remember that the outcome of the sale will be dependent to the outcome of the case. That means two things. Supposing you have sold the property and you lose that case, that means that sale that you, or that transfer that you effected while the case was pending, will be declared null and void. Now once it is declared null and void, the buyer cannot come in and say I am a bona fide purchaser, मैंने तो सही सही खरीदी, मैंने ये खरीदा. No, he will have to submit to the outcome of what that suits or the final orders are. If the final orders is against the current owner who has sold the property, then that transfer will be declared null and void. Similarly, if it is in his favor and he has sold the property, simply because he has sold that property while that suit was going on, it is not going to be declared null and void. If he wins it, then it will be a bona fide sale and it will be upheld. So बड़ा simple और बड़ा easy तरीके से कोर्ट ने एक्सप्लेन कर दिया कि आप वो प्रॉपर्टी जब आपका केस चल रहा है, वैसे तो करना ही नहीं चाहिए. Now as a lawyers we would not recommend you. I don't think if you are in dispute with someone, you should be doing any transfers at all till the final outcome comes. But if you do, what happens? Then this happens, that sale, that transfer is actually based on the outcome of that case, and no appeal, nothing can work once whatever the outcome of that case is. It will impact that transfer for or against. So make sure for the buyers, if you are trying to buy a property even at a lower rate, which is what happens, लोग सोचते हैं कि हम अपनी प्रॉपर्टी को थोड़ा सा मार्केट से डिस्प्यूटेड है, केस चल रहा है, थोड़ा कम करके बेच देते हैं. तो जो लोग ऐसी प्रॉपर्टीज़ खरीद रहे हैं उनको ये जानना ज़रूरी है कि if the judgment goes against your seller, then your transfer will be declared null and void. This is called the Lis Pendens, and you have to submit to this concept of lis pendens. It is highly, highly important. So I think this should answer this question, and a lot of other people who try to do these things, they should be very well aware of the consequences as to what can happen once lis pendens is applicable on an ongoing suit. Yeah.
So there's just one this thing somebody has asked about, that how they can write to us about the legal issues. To that I would like to reply to you that you can write us to at query@NRI Legal Services. So wherein you can shoot your queries and all your answers will be clarified to you.
So we've taken up two topics this time,
Yes.
the daughter's rights and lis pendens, and now we will be continuing depending on the kind of questions we receive in the next live session, further concepts of law, clarifying especially to non-resident Indians who are our clientele as to what their legal rights are and how they can stay protected, and how they can stay informed and updated about their legal rights and their property rights in India. Thank you.